You indicated in a statement that we ran in announcing you as a speaker for this forum, and that is, you talked about how the Constitution, in your words, expressly protected the institution of slavery. Talk to us in that context, because I think sometimes the opposition to affirmative action is done without any kind of adherence to the historical context and the need to equal the playing field. And when you say the Constitution expressly protected the institution of slavery.
You're absolutely right in terms of the history and how ahistorical the Supreme Court's being in eliminating affirmative action. If you haven't read it, I encourage you to read Justice Ketanji Brown Jackson's dissent in the Harvard College case from June 29. And she speaks eloquently of two hypothetical students, one, the seventh generation in his family to go to the University of North Carolina, and the other, the seventh generation that was descended from enslaved persons. And she talks about the enormous effect of slavery on that latter student's life, and how it's a mistake to think that today all of that history is erased. The Constitution institutionalized slavery. Justice Thurgood Marshall on the bicentennial of the Constitution in 1987 gave an eloquent speech of how when the Declaration of Independence said all men are created equal, it didn't really mean it. That there were certainly those of African descent who were enslaved, and those of African descent who were not enslaved certainly did not have the rights of white people. And slavery existed under the Constitution from 1787 to 1865. That's 78 years. It's almost a third of all of American history there was slavery. And it isn't that things changed in a radically better way. I mean, obviously, elimination of slavery is radically better, but the Supreme Court in 1896 in PuLSE versus Ferguson upheld the doctrine of separate but equal, even though separate never was equal. And apartheid existed in southern states and southern parts of northern states and border states with the approval of the Supreme Court from 1896 to 1954. That's 58 years. And so to say at this moment in time, we should have the government be colorblind ignores the way in which that perpetuates a long history of discrimination that traces itself back to the beginning of the country.